And thank you everybody for joining us for how to avoid malpractice and disciplinary actions, general do's and don'ts. As Michael said, I am your moderator, Max Stein. This webinar is part of the Financial Poise series on legal ethics best practices. Slides 7 through 10 provide a summary of the series and this episode. Speaking of the slides, you should understand from the get-go that we will not necessarily step through the PowerPoint in precise order, nor will you have to listen to us read any of the slides. Instead, this webinar, like all Financial Poise webinars, is intended to be a conversation, and I'm looking forward to talking with the panel today. Keep the PowerPoint handy, however, because I will try to indicate what slides our conversation is touching on as we proceed, and they are a helpful reference document. Joining me on the panel for today's conversation are Professor Bernie Burke, Professor Veronica Finkelstein, and John Martin of Rains Feldman Luttrell. We appreciate that you are not spending your time and money to attend this seminar to hear infomercials about us. But if you're curious and want to know more about us, you can find that in the slides as well, slides 26 through 30. Thank you also to our sponsors for today's episode. Mood Hardworking Cannabis, Sunburst Digital, maker of Type to Learn, the #1 typing app for education, and Max Asset, a better way to conduct single asset sales online. This webinar is a production of Financial Poise. To sign up for our free weekly newsletter, go to financialpoise.com/subscribe. If you are attending the live premiere of this webinar, you can submit questions using your web portal. If you are watching this on demand or have any questions after the webinar, you can send an email to info@financialpoise.com. Just include your question and the name of the webinar episode, and we will do our best to get you an answer. And with that, let's get the show on the road. We're going to start with the basics, and here we are working from the information that is on slide 11. Episodes 1 and 2 of this series were very firmly rooted in the ABA's model rules for professional conduct. Today's episode is no different, as the model rules will still play a big role in our conversation, including a few of the ABA's more recent ethics opinions. If you have one takeaway from today's webinar, it should be that whenever you face an ethical issue, the model rules are likely going to be a good first resource. But in terms of understanding malpractice, John, can you get things started for us by giving us an overview of what is malpractice and, just as importantly, the difference between a bad job and malpractice?
Sure. So malpractice is a tort claim. It claims that there was a breach of a duty of professional care owed by an attorney, typically to its client, or some other professional duty arising out of the attorney-client relationship, and that it's a breach of duty that resulted in some damage to the plaintiff, as I say, usually the client. The basic notion is that the lawyer did something that plainly lawyers should not be doing. An example that's used is a client came to a lawyer with a claim. Lawyer failed to file the claim within the statute of limitations for the claim. Client lost the claim. Okay. It's assumed that lawyers know what the applicable statute of limitations are, and that they should, as a minimal matter, file claims within the limitations period. So that's the general nature of a professional malpractice claim. It's not just a bad job. Okay, so it's not the kind of thing that you can look back and say, well, maybe this could have been done. This could have been done better. Maybe there was a different tactic that might have been employed. It's generally not, called to come up with second guessing of what we'll call ordinary judgments. It is saying that some minimal standard was not followed, that the lawyer failed to do something that really any reasonable lawyer in that lawyer's position would have done. And then on top of that, that something bad happened, that there is some compensable damage that result. So in the example of the lawyer who failed to file a claim within the the statute of limitations within the limitations period. One of the things that would need to be established for a malpractice claim is that there was actually a meritorious claim that was lost. That, but for the fact that the claim was lost because of the limitations bar, that the plaintiff would have prevailed on the claim and suffered and gotten some award. So it's both not just bad as in the sense of maybe you could have done it differently, but bad as in below some minimal standard, and then resulting in damage to the plaintiff.
Excellent. Now, one thing that is also going to be the topic of discussion today is disciplinary actions. And John, do you want to touch a little bit on the difference between malpractice and disciplinary action?
Sure. So malpractice or tort claims, they're brought typically by, well, almost always by private plaintiffs. So someone who was a client says, oh, my lawyer did this wrong. Disciplinary actions are brought by lawyer disciplinary authorities. They're looking at a different set of concerns. They're looking at whether a lawyer's action violated rules of professional conduct that are applicable to lawyers, typically embodied in the state corollaries to the model rules. So to give a slightly different example, lawyers are required to segregate the property of their clients, and typically they hold client funds in trust accounts, in client trust accounts. If the lawyer fails to do that, that might not result in damage to the client. It's possible that the client doesn't lose any money, but it's a violation of the rules of professional conduct. It's one that bar authorities care a lot about, because you're really supposed to be segregating client funds from your own. And in that instance, the disciplinary authorities might bring a disciplinary action that could result in the lawyer losing their license to practice law, or having it suspended, or in some other type of relief, like a censure of the lawyer.
Excellent. Thank you very much, John. So now we've got sort of the basics and the fundamentals of what we're talking about when we're talking about malpractice, and what we're talking about in terms of disciplinary actions. Now we're going to dive into some of the specific topics we've got for today. And our first one is regarding responsibilities regarding non-lawyer assistants. And Veronica, to prove my point from earlier, this arises out of one of those ABA opinions. This is opinion 506. Can you tell us a little bit about this?
Sure. So the American Bar Association promulgates the model rules of professional conduct. As you know, they are a guideline that jurisdictions can use when they're drafting their own professional rules. But the ABA is also called upon to issue informal and formal opinions interpreting those model rules, which again are a guide. They are a guide that state bar associations and disciplinary committees can use in interpreting their own rules that they have drafted, modeled off the ABA's rules. And ABA Opinion 506 is essentially a more contemporary update and application of a rule that has long been on the books in the model rule, which is in essence that a lawyer has a responsibility for supervising non-lawyers when those non-lawyers are assisting the lawyer. That's not something new, that's not a secret, but this opinion is an effort to look at the contemporary realities of legal practice today and to realistically apply the rule to the way that non-lawyer assistants are being used today. And that is everything from paralegals and legal secretaries and legal assistants, a more traditional non-lawyer that has long been held to be subject to the rules of supervision, but also the realities of law practice have changed who may be a member of a law firm or an organization. Many law firms now have investigators. They may have in-house professionals who render informal opinions or guide the lawyers as they practice. For example, many plaintiffs' personal injury firms may have nurses on staff or doctors on staff. Defense firms may have investigator type staff who work in-house doing investigations as part of the defense of cases. And then, of course, there is the assistance that can be provided not by people, but by tools, including generative AI tools. And so the American Bar Association, recognizing the changes in the way legal practice is done today, issued its opinion to be a little more ahead of the curve in terms of talking about the supervision of non-lawyers in today's more contemporary legal practice.
Thank you. So, Veronica, in the opinion, what does the ABA opinion say about what lawyers can do and what non-lawyers can do and cannot do to assist the lawyers that they're working with?
Yeah, so the opinion tries to draw a line more between the tasks that are being done and less about the titles, which I think is actually a very helpful spin as the realities of law firm practice change. And there are people in firms who maybe don't have traditional titles, maybe are not called a paralegal, but are doing supportive work in furtherance of the cases that the firm has. So here's where the ABA is suggesting drawing the line in its opinion. There are a category of activities that do not constitute the practice of law. Those can definitely be done by non-legal staff, and there needs to be supervision, but these are tasks that can be sort of divvied up to non-lawyers within the firm. And those are things like clerical tasks, actually making sure the documents get filed, making photocopies, setting up conference rooms and arranging for court reporters, all of those sort of clerical tasks that are absolutely necessary so that lawyers can do their day-to-day work. Those are all things that do not constitute the practice of law. These are traditionally deferred to non-lawyers, and they can continue to be deferred to non-lawyers as long as there's adequate supervision. Other things that non-lawyers do is act as scriveners, take notes during client interviews, maybe attend trial and take notes and report back to the client, or provide advice based on those notes to the attorneys based on what did and did not come out during that day of trial or during a hearing, so that the attorneys can make sure to elicit that information in another hearing or in another day of trial. Those are, again, not considered the practice of law generally. Those are the kinds of things non-lawyer assistants can do, again, with supervision. And then there are non-lawyer services that may be offered by professionals in the firm. Some law firms have ancillary services that they offer their clients, like accounting or marketing services or certain types of sales services. And those are all things that can be done by professionals who are associated with the firm, but are not themselves lawyers. And they would not be considered the practice of law as long as those professionals stay within the lane. So they're just providing accounting services. They're not also providing tax advice. That might cross the line into being legal advice. But as long as these professionals stay in their lane, they can also continue to assist firm and organization clients without practicing law. And then another big category, and really the impetus for the ABA issuing this opinion, was client intake, because that can be a really time-consuming and critical phase of litigation for firms that are handling litigation. And even for firms that do transactional work, there is some degree of client intake that needs to be done. And that can involve a lot of legwork. And client intake, according to the ABA, can be done by non-lawyers who are supervised, but those non-lawyers have to be trained by lawyers, and the work that is delegated has to be reasonable. So what is delegated to a non-lawyer still needs to be the type of work that can be done with lawyer supervision, and not the type of work that the ABA feels is the core work of a lawyer, which can't be done by a non-lawyer and would be unauthorized practice of law.
Excellent. So the intake stuff that you were just talking about and that's covered in the opinion is certainly one of the areas where there's a fair amount of additional information, and one of the areas where, as you note, it's really important. So can you talk just a little bit more about those guide? Bleh. My tongue is very tied today. Sorry, everyone. Can you talk a little bit more about the guidance that the opinion has there?
So the ABA was quite concrete about taking a realistic view of how intake is usually a function at a law firm or organization, and dividing the tasks between those that are appropriate for a non-lawyer and those that require a lawyer. Obtaining initial information from the client or prospective client about the facts of the case. Those are things that the ABA suggests a non-lawyer can do. So a plaintiff calls up, says, I'm looking for a law firm, I slipped and fell, asking that individual, where did you fall? What were your injuries? All of those sort of fact gathering functions, those sorts of questions can be done by a non-lawyer. taking that information and running an initial conflicts check to make sure that there isn't a conflict of interest between the prospective client and an existing or past client of the firm or organization. That's also something that a non-lawyer can do. Again, based on the information that was learned on the intake, that initial check is a bit of it's not quite a clerical function, but it is a largely administrative function of taking the prospective client's name and information and matching it up against other matters that the firm has or have had. And even getting the initial client to sign a retainer letter or to agree to be represented by the firm. If it is more of an administrative clerical function, the ABA says that's again something that can be delegated to a non-lawyer. So in other words, non-lawyers can do a lot of the initial screening, the fact gathering, the conflict checking, and even checking the boxes in terms of the firm's procedures for retaining a new client. And they can also handle certain types of questions from prospective clients, as long as those questions do not require advice about legal services. So if the client has questions about the building location or how many offices the firm has or the hours in which there's a receptionist available to answer the phone at the firm, or even information about the website or where the client can find lawyer bios for the lawyers who may be handling the case. Non-lawyer assistants can point the potential client, the prospective client, in the direction of all of that information. They can handle and answer general questions on their own. But once the questions become more about specific legal services, and perhaps later we'll talk about cases where clients do have a lot of questions at intake and do want to know a lot about who's handling their case and what the legal strategy might be, those kinds of questions should be delegated to the lawyer, and the prospective client should get to have those questions answered by the lawyer directly.
Excellent. So we've got a sense of where the line gets drawn a bit on these intake points. Let's all, before we bring Bernie and John back into the conversation, Veronica, can you tell us a little bit more about what the opinion says about where the line between legal and non-legal work should be drawn on a few other areas?
Yes, so every jurisdiction defines the practice of law differently. And the question as to what can be done by a non-lawyer and what needs to be done by a lawyer is wherever that jurisdiction draws that line. So whatever would be considered the practice of law in that jurisdiction is something that even with supervision, a non-lawyer personnel or staff member should not be doing. Model Rule 5.5a prohibits lawyers from assisting others in the unauthorized practice of law. And so that's why supervision is not enough. If this is a task that is the practice of law, it is not enough that a support staff is being supervised, because that alone, just that supervision, would violate the model rules of professional conduct, and the unauthorized practice of law would also itself be a problem under the model rules, since only lawyers can practice law, are only barred and admitted to practice law in a particular jurisdiction. So lawyers need to understand in their jurisdiction what has and has not been characterized as the practice of law, because that's where the line is going to be drawn. There are some pretty clear places where we can say conduct falls on one side of the line or another. If the client's question involves applying the facts to the law, that is going to be the practice of law. That is the kind of question that should be answered by the lawyer and not by the support staff. If the question involves interpretation of the law, that again is going to be a lawyer task that should not be done by support staff, even under supervision. And even for those tasks that fall on the other side of the line, more administrative, more clerical tasks, the mere fact that a non-lawyer staff member is doing the task, is answering the question, does not mean that the lawyer is off the hook. The bottom line that's made clear in the ABA opinion is that at the end of the day, lawyers are responsible for supervising non-lawyers and ensuring that those non-lawyers are aware of what the applicable rules of professional conduct require and where the line is drawn. And it is the lawyer's obligation, and the lawyer who can be disciplined or sanctioned if it turns out that the supervision is inappropriate, and if it turns out that a non-lawyer member of staff has been performing activities either without adequate supervision or that were the unauthorized practice of law.
Thank you, Veronica. John, as one of the two practicing firm lawyers on the panel, I'm curious what your reaction to what Veronica's been sharing with us today, and how you think it plays out and impacts your practice and your firm's policies.
Well, I mean, it makes a great deal of sense. So let's start with that. I mean, that we are lawyers. We are paid to practice law. We have a monopoly to practice law. We do pretty well practicing law. And if we are allowing lots of other people in our firms to do it, we're not really doing that which we're paid to do. In fact, I mean, I'd note that there's a little bit of an economic issue here that comes into play. As a lawyer who I'm a litigator, and I typically charge by the hour. Okay. And I know that there are legal and non-legal tasks in part because my clients frequently are going to be less anxious to pay me for non-legal tasks. Okay. So if it's something that's genuinely can be handled by someone else in my firm who's not going to be charging the rates that I get to charge because I have a monopoly on the practice of law, they're going to want to do that work. Okay. Conversely, I'm presenting things to courts on regular basis. And that's all involves actual practice of law, involves understanding the law. That's what I'm called upon to do. I would never want to be in a position where something gets presented to a court and they say, well, Mr. Martin, how is it that you've said this on this legal point? And I said, well, it really wasn't me. It was my paralegal who came up with that argument. That's not going to be a good argument because that is plainly not my name is on the paper because I am the one making the legal arguments. So that kind of very practical way of approaching problems is, I think, the way a lot of lawyers do practice it. It's tempting in other areas, particularly where you're in practices that may depend more upon that are not that where there's a volume practice, where there's a lot of routine material that's being done, where more is going to be handled by assistants, where for a variety of reasons the lawyer really does need to be handling various tasks that occupy a lot of time, and where it's tempting to delegate some legal work to other lawyers. But again, I think that there is a very practical sense in which lawyers know that which they have the exclusive right to do and should be doing it. So.
Absolutely. Bernie, before we go to the next topic, did you want to add anything here?
Yeah, a quick note, if I could.
Please.
I wanted to emphasize a couple of things that Veronica has already laid out extremely clearly. One of them is that the line between what is and what is not practicing law is one of the biggest mysteries in legal ethics. That's because lots of non-lawyers have always done and it's accepted that they can do lots of things that lawyers also do. When you have a question that's close to the line, you need to pay special attention. And there's two questions you have to ask. First of all, is this something that my paralegal or other non-lawyer can do supervised? For example, you have an immigration practice, you have hundreds of things pending at the same time. And your paralegal understands the federal immigration forms for particular kinds of matters and does a first draft that you review. That's something that you absolutely can have a paralegal do so long as you review it and make sure it's okay. If you say, fill it to the paralegal, fill this out and file it, you're allowing the paralegal to practice law. But as Veronica pointed out, there are some things that even with supervision, a non-lawyer can't be allowed to do. So in close questions, you need to stop and ask yourself, and don't fall into the trap of saying, but I've been doing it this way for 20 years. Because if you've been doing it wrong for 20 years, what you've just done is confess that you have a long history of disciplinary violations. So everybody ought to review their practices and make sure that this is done right.
Excellent advice. Thank you, Bernie. So we're now going to shift to our second topic for the day, which arises out of another ABA opinion, this one, ABA opinion 507, and it talks about sharing office space. Bernie, can you talk a little bit about the opinion?
Sure. Let me start by saying that the ethics opinion, which is recent, it's from last year, I think. Yeah, last year, is It doesn't break any new ground. It doesn't tell us anything new, but it is a terrific checklist of things that the many, many lawyers who share working space can look at to see that they're staying on the right side of the line as to everything. The way that the opinion is structured is by looking at particular risks to the violation of particular lawyer duties in the shared space context. And I'll try and talk about those the same way. So starting with the duty of confidentiality, everybody understands the duty of confidentiality, and Rule 1.6C says that lawyers have to take reasonable care to preserve the confidentiality of their confidential information and to prevent its inadvertent disclosure. How does that come up in a shared space? Well, if you're sharing space with people who are not a part of your practice, then you have to be extra double careful not to leave confidential documents around shared conference rooms or work areas or on the copy machine or scanner or printer. Why? Because somebody from another practice using the same facilities can stumble across your confidential information, and that is a flat-out violation of the rule, and ultimately could prove to be malpractice as well, if it turns out to be harmful. Similarly, if you work in a shared space where workplaces of different practices are visible to one another, you've got to train people to be extra careful not to do anything in others' plain sight that would be that could disclose your confidential information. That means, for example, if everybody's desks or workspaces are accessible to everybody else in the space, you may have to train on and implement a clean desk policy, because leaving stuff out when people are walking by can turn into a disaster. Similarly with client files. Client files should not be shared in shared space. You should have your own file space, which you can secure as well as is reasonable given your practice. Similarly, when you're sharing a space, the safe space that you have in your office may be compromised. That is, other people may overhear you talking about your matters or talking with your client. So you need to be careful to make sure that confidential or privileged communications take place out of the earshot of anybody who's not a part of your practice. And similarly with things like computer screens, if other people can see if people outside your practice can see the computer screen, then you need to do something like either moving the screen, or there are privacy screens that make it difficult for anyone except the person sitting directly in front of the screen to see. Similarly, if you share a computer network or you share a phone system, which lots of lawyers do, more phone systems than computer networks, you have to make sure that your stuff is securely segregated in a partition of the computer system so that people outside your practice just can't, without black hat hacker skills, get at your stuff. Similarly, if you share a telephone system, you have to configure the telephone system so that somebody doesn't inadvertently punch a button from outside your practice and overhear you. The old-fashioned telephones with multiple lines, which some offices still have. You also have to be careful if you have shared staff, shared receptionists, shared administrative assistants, shared paralegals, that they are as careful as you are in keeping their work for different practices strictly segregated and not letting one bleed over into the other. Last, about confidentiality, we need to confront the reality that lawyers who share space frequently talk to each other in the hallway, bounce ideas off each other. Hey, can I pick your brain? Do you know about? And that's good, because two heads really are better than one. But when you do it, you need to be very careful you're not disclosing confidential information in the course of this informal consultation. How do you do that? It's really easy. Just do it on a no names basis, this sort of I know a guy conversation, or disguise the details that don't matter so that it's not clear who you're talking about. The key is not to make anybody able to link what you're saying with the identity needs of a particular client. And last of all, training. In this particular environment, the more junior lawyers and the non-lawyer staff need to be trained about this stuff, because lots of it is not the least bit self-evident if you haven't thought about it, and they just need to know. So that's due to confidentiality. Next issue.
Bernie, can I, before you go
Yeah.
on, I just want to jump in and note, I think one of the things that you mentioned there is how the opinion has very specific guidance on it. And so I think that's
Yes.
actually a very helpful thing here, because as you were just noting, so many of these things are, on the one hand, obvious, but on the other hand, subtle. And so it can be a little bit dangerous if you don't have that kind of clear guidance from the ABA, that the ABA opinion has here. One of the things that I thought was particularly interesting, and this may be where you were about to go, is the misimpressions that people might get about relationships between lawyers in shared office spaces. Can you talk a little bit about that?
Yeah, absolutely. I mean, ordinarily, where one practice has its own space, it's easy to know that you're talking to somebody from that practice because there's nobody else there. When you're sharing space, it can easily become very quickly confusing whether you are interacting with someone from one particular practice or another. And that can, so what do you need to do? You need to do things that are very clear to people who don't know anything about your sharing arrangement, what space and what people belong to which practice. So, for example, business cards, letterhead, directory listings all need to clearly distinguish who is where. Signage and firm names, and if there's any advertising, have to be strictly segregated. And interestingly, if you've ever called opposing counsel and someone answers law office, there's a good reason for that. And the reason is they have a shared telephone system. So if they answer Smith and Jones, which is maybe the firm occupying the most of the space, and someone is looking for a totally separate practice, if they call the shared phone system, hear Smith and Jones, and then are connected to somebody, they will have the misimpression, understandably, that whoever they're talking to is part of Smith and Jones when they're not. So you can avoid the confusion simply by having receptionists answer a law office, which many, many offices do. Those are the main things to avoid that misimpression. Also, to the extent you can, segregating unshared work or meeting areas is another way of making sure that people don't get confused. That's my list. I think that's
Excellent. Thank you, Bernie. Then
Sure.
the last thing I think we wanted to touch on from the ABA opinion on shared office space was the types of conflicts that might be created in those instances where somebody wasn't quite as careful as you suggested they be about disguising information when picking each other's brains and those kinds of things. Bernie, can you talk about that a little bit?
Yeah, it does come up more frequently and in a somewhat different way in shared office space situations. The It can happen in that context in which lawyers are consulting informally with one another, and one of them suddenly realizes, uh-oh, you're talking about my client. So that being able to describe that and say, wait, stop, this may potentially involve something that you don't want to talk to me about, is just part of the vigilance that you need to have. There's also the issues of imputation. The general rule in the model rules is that if one lawyer in a practice has a conflict, every other lawyer in the same practice has the same conflict, whether they have any involvement in the matter or know any confidential information about it or not. It's the technical term is imputation. The conflicts of one are imputed to all. Sharing office space does not create imputation. But it does create the risks we've just talked about, which can amount to the same thing, because if people outside your practice are actually learning confidential information, then you have the same conflict problem. Similarly, to the extent that people get the misimpression that the firms are affiliated or are the same practice for the reasons that I just talked about, then then the client's reasonable understanding about the relationship between the firms is the one the law will impose on both firms. So it's the lawyer's job to be extremely clear about that. Lastly, if you have shared staff and different practices in the same space end up being on the other side of the caption from one another. You have a bunch of family lawyers sharing space, and one's got one spouse and one's got another in a divorce. It happens all the time, really. Then if you have shared staff, they can't work on both. Because you can't, unlike a computer system, you can't put a partition system in your paralegal's brain. And so when you have adverse clients in shared space, shared staff have to strictly work on one or the other. And they need to be very carefully trained to understand that this is something where they absolutely can't talk about or look at files from the other firm about the matter. If you do all those things and just get in the habit of doing them and making sure that your people are in the same place, they understand all these things, then sharing space is easy and it's a terrific idea. Obviously, it saves money, and it's great for everybody. There are a few states that actually discourage it, but nobody forbids it, so long as you make sure that the things we just talked about didn't happen.
Thank you. John, I'm going to jump to you again and inquire, as you were hearing Bernie and me talk a little bit about these things, the thoughts that were running through your head.
Yeah, I mean, I guess so there's a whole host of problems that happen when lawyers forget who their clients are. Okay, these are issues that kind of come up when lawyers forget who the other lawyers on the matter are. I mean, who their firm is. Look, we're entrusted with our clients' competences, and we need to understand who's really on who is, as a matter of law, on our side. So the other people in our firm. Those are people we can share information with. But if not, we got to be really careful about that, because that's the circumstance in which we're allowing that which has been entrusted to us, which is our clients' information. If we're letting that out into the world, that's a bad thing. All sorts of bad things happen. Okay. And as someone who was in shared space at one point, I am no longer. I'm now with a firm, a much larger firm. But in those circumstances, that is one of the things that makes it difficult, and that you need to keep in mind at all times, which is your practice is your practice is your practice, and your neighbor may be your friend, he may be a wonderful person, he may be something you want to collaborate with on a case here or there. But it's going to be if you're both representing the client, great, then you're both representing the client. but that's not the default rule, okay? And that keeping in mind that a lawyer is not associated with you on this case, is not working with you, is something that every lawyer needs to keep in mind when taking advantage of any kind of shared service. It's making sure that the client information that belongs to that lawyer's practice, that lawyer's firm, is protected.
Good advice, absolutely. Always a good idea to remember who your clients are and who your colleagues are, and make sure you keep that clear. Veronica, did you have anything you wanted to add here?
No, I mean, I would just follow up by saying that all of the same rules apply that would apply if you weren't sharing office space. It's just more tempting not to remember about those rules when you're in the same location. So just put yourself in the mindset of, if we weren't in the same location, if this was my friend who worked across the city, or, you know, I was sharing some, you know, services with somebody who worked in another town, would I share the same confidential information with them? And that should give you a good rule of thumb as to the answer.
Indeed, and I will even go a step further and say, that same principle applies even if you are in office space that is all of one firm. You still have to remember these things. You just have a boundary effectively that's a little further away than it is in those shared office spaces. Next, we are going to go to another topic. This one relates to mandatory withdrawal, and Bernie, can you talk a little bit about?
Before we do, could I add just one thought? I'm sorry to interrupt you, Matt.
Please, no, go right ahead.
It occurred to me from John and Veronica's remarks. This situation, a lot of people think of it as, oh, that's what happens with solos and small firms that share space, and that's the most common arrangement. But lots and lots of big firms rent out offices or little corners of their space that they're not using to other practitioners, and it raises all the same issues. If you've got one person on your phone system who has a separate practice, you can't answer the telephone, Smith and Jones. So just a thought.
Excellent point. Yes, that certainly does make sense, and certainly large law firms are big landlords for small law firms.
Absolutely, happens all the time.
Yep. Now we are going to go to that mandatory withdrawal topic. And Bernie, can you talk a little bit about a recent amendment to Model Rule 1.16?
Sure. I'm getting a lot of exercise here. The source of what makes this potentially very important and also very confusing, and it is that for as long as I've been practicing, which is a distressingly long time now, there has been a great deal of unclarity about the extent of a lawyer's duties to investigate or inquire into situations in which a potential new client or a current client may be intending to or actually using your services for something illegal or even downright evil. And if you think back to all the major scandals, like the savings and loan scandal in the 80s, the accounting scandals in the early aughts, there's always a lot of lawyers milling around, and famously in a congressional investigation regarding the savings and loan crisis, a member of Congress demanded to know, where were the lawyers? In other words, you should have known this was going on and either stopped it or quit. But the question is, what if you just think there might be, or you have a hint, or you don't know anything at all? What's the level of the duty? And in fact, there's been surprisingly few decided cases in the malpractice context. And there's been very little decision in the disciplinary area either about what you need to do and how much you need to do when and how aggressive you need to be in figuring out that your client is doing something that in retrospect is going to turn out to be a disaster. And that can be all kinds of things. It could be a Ponzi scheme. It could be that your client is manufacturing and distributing dangerous products or drugs. It could be money laundering. It could be any number of things. So Model Rule 1.16 is the rule about when you either must or may either not take something on or get out of it, withdraw. After a process that we'll talk about in a little bit, the ABA has now officially adopted, and it is part of the model rules, two critical amendments to Rule 1.16, and they are to Rule 1.16a, and they are these. Added is a key sentence, and 1.16a is about when you have to not take something on or you have to quit. It says a lawyer shall inquire into and assess the facts and circumstances of each representation to determine whether the lawyer may accept or continue the representation. So that's a duty of inquiry. We'll talk later about what it might mean. And there's a new subsection 4, which is you have to turn it down or withdraw if the client or prospective client seeks to use or persists in using the lawyer's services to commit or further a crime or fraud, that's any crime or fraud, despite the lawyer's discussion pursuant to Rules 1.2d and 1.4a5 regarding limitations on the lawyer assisting with the proposed conduct. So what this part is telling you is, and the easy part is, if you know your lawyer's using your services for evil, you got to deal with it. If your inquiry makes you believe that they are, well, the first thing is Rule 1.d says you may never advise a client to violate the law, but you may talk about the implications of what the client's doing if it's illegal. And Rule 1.4a5 says if the client is expecting you to do something which would violate the law or violate the rules of professional conduct, you have to come right out and tell them, I can't do that. And often these sorts of problems are resolved when a lawyer says to a client, you know, you probably didn't realize this, but you're actually technically committing securities fraud. And the following awful things could happen to you. So you should stop. And often the client says, wow, I had no idea. And they stop, but sometimes they don't. And sometimes they lie to you about whether they will, if they're the client who's committing those sorts of crimes in the first place. So you not only have to tell them it's illegal and you can't do it, but if they say, well, I'm going to do it anyway, or you find that they're doing it after promising not to, you got to quit. That's what Rule 1.16a is about. It's about withdrawing.
And Bernie, can you talk a little bit about the particular context that resulted in this most recent amendment?
It is, well, at least to ethics geeks, kind of interesting. The background is that over the last 40 years or so, the scope and efficiency of the international banking system has made it increasingly easy to engage in money laundering, and particularly international money laundering in the service of terrible things like drug distribution and terrorism. And the Department of the Treasury has gotten progressively and increasingly concerned about this because domestic American banks were engaging in these kinds of transactions, these money laundering transactions for something that turned out to be the Sinaloa cartel or Al-Qaeda. And that had to stop. And there have been increasingly stringent obligations on the part of American banks who have a financial temptation to do this because they charge exorbitant fees for this kind of stuff and they really want to collect those fees. So Both the degree to which they have to keep records, acquire, and monitor what's going on regarding regarding money laundering, which is defined in various federal laws, has gotten stronger and stronger. In the meantime, lawyers got involved, and lawyers who either wanted to earn fat fees or lawyers who were sympathetic with whatever the cause was that was illicitly being served, began to assist clients in evading money laundering regulations when in fact that was going on. The Treasury noticed that more and more there were actually domestic lawyers involved, and not only were they documenting and carrying out these transactions, but they were coming up with all kinds of ingenious ways to make them less visible. The result is that the Treasury Department recently turned to the ABA and said, if you don't do this, we're going to impose regulations that put as many obligations on you as a domestic bank, really onerous, detailed monitoring, record keeping, and really serious penalties if you don't. This finally stirred the ABA to action, and this amendment to the mandatory turn it down or withdrawal rule is the result. What's interesting about it is that while the triggering concern was money laundering, the rule ends up in a form that says any crime or fraud. So it's much broader than the triggering concern, and it's unambiguously so.
That is interesting, Bernie. I want to ask John to jump in here a little bit and talk about some practical implications of this, and then we do have one more topic that I want to get to. So I apologize for jumping in, but John,
Sure.
Talk a little bit about what you're thinking.
Well, I got very quickly then. Look, some of this, the business of wanting to know what your client is actually engaged in and not helping with fraud, okay, are things that I would hope that people would be onto for some period of time. That this latest change shouldn't have changed that. It's very difficult, candidly, to provide good advice to clients if you don't know what they're up to, and if they decline to tell you what you're up to, that would normally raise the hair on the back of your neck. I mean, that's something that's a very it's very tricky. And if all that you've got is you've got a very bad feeling, but you're being promised a fee, that's probably not a circumstance you want to get yourself involved in. That's going to be a substantial problem. I'll leave that there, given that I know we have another topic we want to get to.
Max,
Excellent.
I can wrap this up very quickly if that's okay.
Sure.
So where does this leave us as a practical matter? Two important takeaways. One, right now, not a single state has put this amendment to Rule 1.16 into its rules of professional conduct. But it just got enacted, so it's not clear how many will. And it's likely that some will, although some won't, because this is very controversial. The other point is, once the rule is in place, it's really unclear when and how much you have to investigate. Sorry, and a third point is the real worry I would suggest for lawyers is that somebody who gets burned in a Ponzi scheme or the distribution of a dangerous product or other sorts of things that this rule calls for may use the rule as a basis to claim there was a breach of lawyer duty owed to them that is a basis for civil liability. Now, the model rules are not supposed to be a basis for civil liability, but most states say we will refer to them as informative about what lawyers' duties are for the purpose of civil liability. And the day that you start becoming liable to the victims of a Ponzi scheme or the victims of a dangerous drug is the day that your insurance premiums go way up and your liability exposure skyrockets. So be aware that this could be coming.
Thank you, Bernie. So Veronica, for our last topic of the day, we want to talk a bit about the benefits of honesty. Can you talk a little bit about that and how that relates to the model rules, even though perhaps it should be obvious and intuitive that one would be honest? There are both ethical and moral reasons to do it.
Yeah, I mean, don't they say honesty is the best policy? It seems like we shouldn't need 3 different rules to tell lawyers that they have to be honest, and yet we do. So let's talk about those rules just briefly and some interesting examples ripped from the headlines of either lawyers who were sued by their clients or former clients or face disciplinary action for being dishonesty. The first rule is Rule 1.4. which governs lawyers' communications with clients, and unsurprisingly, it prohibits lawyers from lying to their clients or prospective clients. Recently, the Virginia Supreme Court allowed a lawsuit to go forward by a client who got some misleading information when calling to retain a firm in the first place. So here is hearkening back to the first topic that I talked about, why you need to supervise non-lawyers when they are doing screening and intake. So in this particular case, the law firm represented to the potential client that a particular partner would be handling the case. In actuality, the case was handled by an associate at the same firm. As best as anyone can tell, it was handled well. There were no allegations of any malpractice, but it was not the partner who actually handled the case. And the client was unhappy when the client discovered that they had been lied to and sued, and essentially was allowed to go forward on a theory of fraudulent inducement, that they had been promised a partner would work on the case, and instead an associate worked on the case, and noticed that this was not a malpractice case, so it didn't really matter that the outcome was okay or that the associate had done work that was within the standard of care, because it was a fraudulent inducement theory under Vermont's Consumer Protection Act. So that is why you don't lie to your clients or prospective clients. How about opposing counsel? Why don't you lie to opposing counsel? Well, Model Rule 3.4 requires honesty in dealing with opposing parties and counsel. There is a carve out for negotiation tactics. You can obviously engage in a little bit of puffery when you're negotiating, trying to settle a case, or you're trying to bargain for a deal. But we're outside of that context here. You can't just outright lie. And that is what a lawyer did in Tallahassee, Florida. He claimed that he missed a deposition because he didn't get the deposition notice because it went to his spam box in his email inbox, but that turned out not to be true. Though he did have a good excuse for missing the deposition and blowing it off entirely. He was traveling to see the total solar eclipse. And when opposing counsel found out that the lawyer had just blown the deposition off because he wanted to go see the eclipse, opposing counsel moved for sanctions in the case. It's currently pending, and opposing counsel is seeking roughly $8,000 in fees and costs before a federal court in the Middle District of Florida. So that's why you don't lie to opposing counsel. If you need to reschedule a deposition, you say so clearly rather than lying to opposing counsel. And then, of course, we have a rule that prohibits lying directly to the court, Model Rule 3.3, which requires candor towards the tribunal. Probably the riskiest of these 3 things, because if someone is going to throw the book at you for lying, it's probably a judge who's going to be very upset at being lied to. This one is sort of a inexplicable case ripped from the headlines. A lawyer who had actually gotten into law school based upon a very compelling personal statement about having to recover from stomach cancer, and then went on and graduated law school and was admitted to the bar and had a legal career, and on multiple occasions asked for extensions in litigation because he was representing that he was continuing to undergo cancer treatment, and also represented that his son had been ill. The court discovered that neither of those things were true, and it's worse than you might think. Not only was he not sick with cancer, nor was his son sick, he had never had cancer ever, not before he applied to law school or during the pendency of the case. And his son wasn't sick because he didn't have a son. That didn't exist. And he was disciplined and found to have violated the applicable rules of professional conduct in a variety of different ways, including lying to the court in written pleadings, and having lies in his statements to the disciplinary committee. And he ultimately faced a 3-year suspension. And it is if you want to go and read the case, the case is in Ray Field. It is a beautiful discussion of all of the reasons why there is a duty of honesty imposed upon lawyers and all of the consequences that can follow a lawyer who is bold enough to lie about things as serious as Vince Field lied about. So that is why you don't lie to the court, because you will almost certainly face consequences in that litigation from that judge, and very likely a referral for disciplinary action as well. So really, honesty is the best policy. If you don't think these rules are enough, look at the consequences that attorneys have faced. And these are just some of the cases. If you were to go look for disciplinary cases involving dishonesty, you would find many of them. Lawyers have found many creative ways to be dishonest. I would advise against all of them. The best way to avoid malpractice is to follow the rules, and the model rules of professional conduct could not be more clear about the need for honesty in virtually every situation. Puffery during negotiation, I would say, isn't even really a form of dishonesty. But the rules are quite clear that aside from that sort of context, honesty is always required.
Thank you, Veronica. I will say, watching the faces on the panel as you were going through those stories was quite entertaining in and of itself. John, you in particular were, I think, a bit amazed by some of, at once amazed and yet not amazed, right?
I am actually familiar with the Field case, and Veronica, I think there's another element to that, which is not only did Field lose his license to practice law, it is my recollection that that lawyer lost their law degree entirely because the law school revoked upon finding that they had been lied to as part of the application.
False pretenses. Yes.
Correct.
Yes.
So listen, I mean, on this one, it's pretty straightforward, which is, if you don't understand that lying is wrong, we cannot help you. I mean, it is a very fundamental duty.
Indeed it is. And as I always say to clients when I am preparing, or witnesses when I'm preparing them for deposition, there are all these moral reasons, there are all these ethical reasons why you should always tell the truth. And there's a practical reason. When you tell the truth, you only have to remember one version of the story. You don't have to remember multiple versions, and it makes life that much easier. With that, I will thank all of you for attending today's panel, and thank our panelists. Thank you for joining another entertaining yet educational production of Financial Poise. Look for Financial Poise webinars wherever better continuing education webinars are sold. Thanks, everybody.
Thank you all.